Hello and welcome back to the Argyle HR Solutions Expo. My name is Vicki Lynn Brunskill with Argyle. It's great to have everyone joining us today. Just a couple of notes before I turn things over to our speaker for this session. First, a quick reminder to stop by our sponsors' virtual booths at any time during the event and for the following week. Our partners are committed to providing you with valuable content and a great overall experience. And at any time during the event, you can visit those booths from the main agenda page. Thank you all again for joining us today. Now let's get started. Without further ado, I would like to introduce Scott T. Lashway, partner and co-leader of privacy and data security practice at Manette. We are so excited to have Scott with us for a keynote presentation titled Tech Compliance Update for HR Leaders. Welcome, Scott, and over to you.
Thank you very much, Vicki Lynn. It was a pleasure to join everyone here today. I'm going to provide as practical advice as I can possibly give in 30 minutes on the emerging world of not only data privacy and all of the risks of dealing with our employees and applicants' data and how our employees use company data, but we're also going to talk a little bit about some legal considerations and compliance considerations with respect to emergence of new technologies, including AI that you've been talking about, listening to about today. So a little bit about our group. And obviously, there's a constant and never-ending challenge of protecting employee data within our organizations. The use and proliferation of data, our reliance on data, our reliance on analyzing data, both for employee management, but also obviously for growth of our company's objectives and their businesses has never been more pervasive. We've seen new technologies being introduced at lightning speed to our environment, upgraded technologies from what we saw 10 or 15 years ago, and then new abilities to process data that are emerging constantly. So just a little bit about the challenges of protecting employee data. So first and foremost, and some of this is obviously recycled messaging from things that you all do every day, but we have to make sure that we have our employees' trust. So with the prevalence of cybersecurity risk and the constant conversation about the theft of data, whether it be from my employer or from my doctor's office or from my social media company, Americans in particular have never experienced the theft of their personal information like we do today. Some have gone completely numb, and others have kind of gone angry and mad. And we've seen a heightened amount of lawsuits around the protection of data. We've seen a heightened amount of lawsuits around the protection of employee data. The costs of a cyber incident when it impacts employee data typically is higher than per record than when we see consumer data impacted, for example. And of course, you all have a lot of information about your employees. So it used to be just the information that you had that was part of the job application or that was collected in the normal course of managing that employee. Today, employers play a much larger role, often through employees' use of technology, both for personal and professional reasons, into an employee's life. So if you think about the laptop that your employer gives an employee, the amount of information that can be gleaned about that employee that's taken from that laptop is remarkable. Organizational reputational risk. And so we see our customers and our clients expecting companies to protect confidential information, whether there's an obligation under the law or not to. And I represent companies in defending these types of lawsuits, but we see the plaintiffs bar and plaintiffs and former employees constantly saying that you have an obligation to keep this information secure. Generally, I would say that they're wrong under the US legal regimes, but it hasn't stopped them from bringing new suits. There's also this loss of trust that can impact ongoing and future business opportunities. So, there's one in the news today where a genetic testing company that has a pretty significant market presence is being accused in a lawsuit of not informing certain individuals of a reported data breach. And it's getting a lot of attention given how this particular organization collects information. It's consumer focused, and it will probably get a lot more attention going forward. So that loss of trust could potentially impact future business opportunities for your organization. And then, like I said, we've seen a lot of litigation around this. In particular, and we'll talk a little bit about state privacy laws in a minute, but in particular, we see things like California, where there's a $750 per person statutory damages if the security procedures are not reasonable. Now, security procedures generally will follow privacy controls, meaning how much of the data are you collecting and for what purposes. And then we've seen some states like Connecticut and Ohio give actually affirmative litigation defenses for adequate security controls and programs that meet certain obligations, like following certain laws and best practices. And there we go. Sorry, I'm having a little challenge with the slides. So we've covered this in past programs that I've provided, but I just want to provide it again. This is a little bit of a different take on it. So the CCPA has an exemption for employment data and business to business data. Now, why is this important? Well, it's important because not all privacy laws, even though they're becoming somewhat routine around the United States, we have about 15 now, they don't all provide exceptions or exemptions for employment data. And that's particularly important as we work from one state to the next in trying to create a baseline for our privacy programs, in particular, not just our employees, but our job applicants. Where does that get more complicated? Just as an example, you have a job posting that you push out through a vendor, and it ends up on LinkedIn. Whether that data is coming back into the organization or whether it's being handled under LinkedIn's privacy policy can create some confusion as to obligations under these privacy laws as to who owns the data, what you can do with that data, with whom you can share that data. And those nuances are particularly important and need to be carefully crafted around, because some of that data coming in the door, we know you might want to use for other purposes, whether it be diversity reporting or diversity considerations or evaluation of the level of candidates that you're getting, whether you want to use new technologies like artificial intelligence to at some point inform the organization how better to recruit. So both those are for both considering technology used today and technology used tomorrow. Those types of exemptions on whether employment data is regulated or not is particularly interesting. Of course, California's exemption expired last year. And so we now see states regulating this data from not just the HR and employment perspective, but also the comprehensive privacy law perspective. This slide gives you a bit of an overview of regulation of employment records or employment data at the state level. I won't go through this slide. These slides are available through Argyle, and we built it so that it could give you at least a lens into the considerations for what you can and can't do with data. But to say something that I've repeated here before, paying attention to state law on this is critical. One of the state laws that we think you need to pay particular attention to, and there will be absolute growth in this space, is the biometric laws, both of Illinois, Texas, and in Washington state. Illinois gets most of the attention. It was kind of the first that dealt with this. Biometric data is, think of a retinal scan or a thumbprint. Facial recognition could be a biometric as well. And the Illinois law is relatively straightforward. It is challenging to comply with and has become really confounding for employers in Illinois due to some basic obligations that are present in the statute. One of the problems with it is that there's a private right of action. And so that private right of action has led to literally hundreds of lawsuits. Resolving those lawsuits has been extremely expensive for certain entities, far more expensive than what we've seen under other state privacy laws so far. And a big problem that these laws provide or present to an employer is this idea of consent. and the idea that you need consent to either sell or disclose the biometric information. And disclosing the biometric information could potentially include sharing it with a third party for analytics purposes or new data analysis or data use purposes. And so you may have consent to collect it so that you can authenticate that the individual walked into the manufacturing center, that I worked my hours in that manufacturing center, because you could recognize me coming and going, whether I didn't take too long of a lunch shift, but whether you can use it for other purposes. For example, again, say diversity analysis of your workforce, basic health conditions. That's a different potential collection regime. It would need particular attention as to whether you need consent to use that collected data for other purposes. This also gives you some details that we think will be helpful as you consider applicability of these laws. Even if you say, I'm not doing business in Texas or Illinois or Washington, this law is likely coming to a state near you. We are seeing many states, in addition to considering comprehensive privacy laws, also consider biometric privacy. And our clients who have had to deal with these issues all report that they are remarkably complicated and they're very difficult to get out of the courts, especially in Illinois. So you can't have a privacy program or a technology program these days without thinking, geez, is the federal government going to come to the rescue of all of this? And the answer is probably not. So in the last year or so, we think Congress has gotten closer than ever with the ADPPA. We love our acronyms in the privacy world. This would be a federal comprehensive privacy law. Currently, federal law has been focused on certain industries, financial services and healthcare, for example. The FTC takes obviously a wider view through their Section 5 authority, but this law in particular would adopt something closer in form to the CCPA, and it would be something that was foundational to every person residing in the United States. It would regulate third-party data collection and application of algorithms to data, and it would create a potential private right of action, meaning you'd see an explosion of lawsuits under federal law and in federal court. I don't think it's going to get passed in the most recent form, but it seems like red state and blue state congressmen and women are closer than ever to acknowledging that American businesses need some level of certainty as to privacy rights with respect to the handling of data. Now, not to get political, but it is fascinating as a privacy lawyer to see what's been happening in the Supreme Court with respect to privacy rights and constitutional rights, and then across the street in Congress, obviously an active debate about whether there are privacy rights fundamental to the handling of personal information. All right, so I was rushing through all that, so please forgive me. I want to spend some time here. So artificial intelligence, one of the questions we get as a lawyer in this space is, what does it mean to be an artificial intelligence lawyer? Well, there really isn't an artificial intelligence lawyer. We come at this, the law comes at this issue from various lenses. So there's been a significant focus on IP rights. That's kind of the New York Times case, and there's another longer pending case in Delaware, where there's this idea that the data that goes into artificial intelligence may have some sort of property rights. So let's apply that now in the employment context. So do individuals have a property right in the information that they share with you if they're an employee or an applicant? That's probably something that needs to be sorted out under the law, to think about whether you have the ability to use that data for purposes outside of the reasons why it was given to you. So typically employment data is given to you for background screening, or for employment management, or for benefits, or for payroll, or something to that extent. To the extent you're using it for other purposes, I think historically it's fair to say that most employers felt like they could use that data for their own purposes, so long as it was being held in confidence and handled with confidentiality in mind. I think with the privacy rights serving as a context, and individuals thinking that they have a right to privacy in their personal data under U.S. and state law, I can debate with you whether or not that's true or not. I think we're going to see more employees taking issue with the handling of their personal information by employers, especially when that information may be used to inform artificial intelligence or machine learning. And by artificial intelligence, all I'm using that word to mean for my purposes here is technology that can learn on its own. So very, very broad brush. Um, State privacy laws, like what we just summarized, and the FTC have expectations that limit the use of the data. And that expectation generally is you can use it for the purposes for which you told the individual from whom you were collecting it. And that new use cases may require consent of that individual. So if you collected information for background check, we know that there's issues with, say, the Fair Credit Reporting Act with that information. You also may want to consider whether there are other limitations. Now, someone might say, well, geez, we never use our employee information for training artificial intelligence. But we know that to train large language models, you need a lot of information. And so if you're developing new technologies in the HR space, the HR management space, I have no doubt that you'll see vendors coming and wanting to get access to employment information, employee information. Profiling and automated decision making is a real concern with respect to artificial intelligence. So an example that we often use is the life insurance industry back in the 1980s faced considerable regulatory activity and oversight with respect to the handling of certain viral diagnoses, in particular with respect to handling HIV status for homosexual males. And they were alleged and accused to be treating homosexual males with increased mortality risk given the explosion of HIV in that population. And whether or not that was profiling or a bias was what the argument was, whether it was happening and whether it was happening. Now, that was looking at underwriting decision, which is based on large tables. Like large language models, artificial intelligence certainly will have bias at times if it's not developed properly. That's a big if. I'm not saying they all do, but we'll want to be very careful on deploying artificial intelligence or the technology that is relying on artificial intelligence with respect to any profiling or automated decision making. You can imagine scenarios here where you're trying to become better at promotion opportunities, applicant considerations, or where you're trying to do good within your organization. But unfortunately, the technology may be spitting out data that doesn't quite align with your expectations. Now, I just want to be really clear. I don't have bias against artificial intelligence. I think it is a remarkable technology, and it's been in play for probably 50 plus years based on one of our clients' assessments. Who's been using it a long time. And there's massive opportunities within your organization, both from a management perspective and obviously your employees are interacting with it, wanting to interact with it, which we'll talk about in a minute. One of the things that we'll want to pay particular attention to in the HR space is President Biden signed an executive order that was authorizing all of the cabinet agencies to evaluate use of AI and regulation of AI. And in particular, under the executive order, the labor secretary was authorized and directed to develop best practices on the evaluation of employees and applicants impacting of the AI data related collection and use activities. That will take a long period of time. And we're up against an election cycle. What happens with this post-election, depending on who wins for the presidency, I think is a little bit up in the air. But we do believe this is coming to the United States government, across the government, regardless of administration. And we do expect the Labor Department to play an active role in evaluating use of AI and AI technologies. This gives you a little bit of insight into how a data lawyer like myself views AI and where our role is. These are considerations that we ask ourselves and ask of our clients when we're advising on the use of AI. Data that's subject to legal frameworks governing the use and disclosure. We've talked a little bit about this, but it gets very granular as to whether or not the particular regulatory regime regulates that data use. So here's some examples. So who's the data about? It's the data about residents of states with a comprehensive privacy law. Then if yes, it needs to be handled in accordance with that law. Whether that requires you to get consent to use that data for these new technologies or to share with third parties, or whether it requires just disclosure is something that may be dependent on which state and which law. And those are two very different regimes. How are we using the data is another question we have. So the FTC and state privacy laws require affirmative consent before using using the data for new purposes. So if you collected it for employment purposes and you want to use it for something else, you need to evaluate whether or not you have authorization within the applicable privacy law or the FTC's authority. And then the final thing that we're looking at amongst many is what protections do we have? So the companies need to protect the data assets with respect to their use in AI tools. So this kind of gets to how our employees are using company data, but AI tools use a continuous learning model most often to refine and update how they're processing whatever the input is. And companies are becoming very wise in limiting use of their data to train large language models. A lot of them are focused on things like copyright and other property rights. We're also focused on things like Computer Fraud and Abuse Act. Where are you getting the data and how are you getting it? Examples there are scraping LinkedIn. Who owns that data and can you use it for actually training your models? Or is the vendor you're about to hire to provide you employment management services? Do they have a license to use all of the technology, including AI, that they're going to deploy for you? And then employees, we believe, are going to be, and they have been asking questions about how data about them is being used. So if you have contracts or other representations in your employment and application materials, you'll want to be very specific that you're meeting those guarantees and those obligations and that you're giving yourself enough flexibility when presenting those materials to use the data how you so need and so desire. So laws regulating automated decision making. There's both directly and indirect regulation of this, right? So before using AI to make a meaningful decision, you need to actually consider what restrictions may apply. And so we've talked a little bit about the contractual restrictions that may or may not apply. But we want to think about the effect of the decision. So a legal analysis is likely going to be required to determine if the AI's decisions will have legal or similarly significant effect. This can include, for example, to take a first cut to reduce a population, say an applicant population. And that legal effect could be discrimination, right? So you're all familiar in the HR space with the ramifications of using discriminatory hiring practices or promotion practices, right? Employers have been dealing with this for a long time. Using technology doesn't change that consideration and doesn't necessarily mask obligations not to use discriminatory practices. And that's just an example. And I'm not an employment lawyer, I'm just a data lawyer, but it doesn't change the obligations not to violate the law elsewhere just because you're relying on technology. So your understanding of how the technology works, whether there are legal implications around the use of that technology and what you're feeding it, and then the output remain front and center. If it does, then there's state private comprehensive privacy laws that allow these individuals to opt out of automated decisions. So this is something that we're seeing rapidly expand, where individuals can say, yes, you can collect my data because you're my employer, but you can't use it for automated decision-making processes. This is something that kind of comes out of Europe. You can obviously see it in my example, the life insurance industry back in the 80s and the ramifications there. That wasn't so automated. That was just updating tables. But it was still something that that regulators were asking questions about, and now individuals have rights where they can say, well, we're going to opt out. And then we talked about the discrimination. The concept of similarly significant effects is new to US law and not as new to Europe, where the GDPR came into effect in 2018. So European regulators offer these examples where this is prohibited activity, but if you're using automated decision making and you're affecting someone's access to health services, you're denying someone employment opportunity or putting them at a serious disadvantage using differential pricing or depriving someone of opportunities based on the actions of others. Those are all things where if there's even a hint that that could be the outcome of your use of the technology or the automated decision making, then you'll want to pay very particular attention to your legal obligations and your legal ability to deploy the technology. One of the things that we've talked about a little bit today is who owns data. And so this is something that is not new, but it's certainly front and center with respect to employment data and the use of AI. Because those tools rely on the continuous machine learning or learning that I was speaking to earlier, this idea of once you put data in, you can never get it out is real. And so if you mistakenly put data into a large language model that isn't necessarily yours to use, there can be real challenging that the issues that the technologist can answer, I can't. As to now what happens, right? Under the law, we know what happens when you misuse someone else's property, but understanding who owns that data that might be in your custodianship is something important. And that gets back to that question of what can you use it for? I'll note, there's a bunch of bullets here that I won't read to you, but these are all considerations that we're asking clients when we get these questions. But corporate contracts typically preserve the company's ownership of its data in any form and would prohibit vendors from using confidential data. That's not just personal information, but that's even, say, your financial information, your benefits information, your payroll information. At this point, we are seeing an explosion of entities that want to collect data for purposes of developing their own artificial intelligence. And you need to pay very particular attention to the vendors that you're responsible with working or you're responsible for sharing data with to ensure that they're not doing things that they're not allowed to do. I would also encourage you not just to rely on the contract. You should get affirmative statements as to what they're going to do with your data if there's any suggestion that they're going to use it to train new technologies where your data is not supposed to be used. We've seen organizations say, yeah, no, the contract is clear, we're not going to use it, but when in fact we know that they want to. And so be very careful there and ask. There's probably not enough questions you can ask. This kind of walks you through this consideration of who owns the continuous learning data that we're paying particular attention to. So let me just pop back out for a second to overall kind of cybersecurity risk that is present in what you all do every day. And I'm going to try to wrap up here in just a minute. We've seen an explosion of events where organizations are confronted with vendor risk. And we gave a little bit here, but your employees are at the front line of that. And we ask employees every day to be very careful, not only with the data that we're using for things like artificial intelligence, but also the data that we're using in everyday employment activities. The deck goes on to talk about how to mitigate some of those risks, but I'm going to leave it there and thank everyone for attending. As always, I ran out of time and I have a lot more to share, but thanks for sitting through my 30 minutes. Thank you,
Thanks,
Lynn.
Scott. Thank you so much. Yep. Again, you can request these slides through Argyle, so you can get a copy of these. And Scott has shared his LinkedIn information, so if you wanted to get in touch with him, I'm sure he'd be happy to hear from you. Thank you again, Scott, for another wonderful keynote. Lots of great content there. And I want to thank everyone else for joining us today. This session, along with all of today's content, will be available on demand following the event. This does officially conclude the Argyle HR Solutions Expo live look at cutting edge tools. Thank you all again for joining us today and engaging in our content. Thank you again, Scott, and everyone have a great rest of your day.